Honour. The next witness is Mr Ben McDevitt. I call Mr McDevitt. He'll be appearing by ABL.
Thank you. Mr McDevitt, it looks like you're on audio. Thank you. Mr McDevitt, it's Judge Armitage here. Thanks for making yourself available to assist with the inquest. It is very much appreciated. And before you give any evidence, do you promise to tell the truth?
Yes, I do, Your Honour.
Thank you.
Sorry, can you hear me okay?
I can hear you. Did you have any difficulty hearing me?
No, it's okay. It's just that my computer's sort of stuck up against the wall, so I didn't know if I was close enough. I'm sitting behind the desk.
Okay, yeah, no, it's pretty good at the moment. If we have any difficulties, we'll let you know. But we'll let Mr Coleridge see how you go. If you can't hear Mr Coleridge, let us know, because he's a little bit further away from a microphone, and we can make arrangements for him to be closer to the microphone if you need it.
Yes, Your Honour.
Mr McDevitt, before I ask you anything further, can I ask you to state your full name?
My full name's Ben McDevitt.
And your current occupation?
I'm retired.
But before that, you spent something like 38 years in various law enforcement roles?
Yes, that's correct.
Before I ask you anything further, I understand that you'd like to say something briefly.
Yes, Your Honour. I just wanted to just make a couple of opening words, if I could. I'm aware that members of Kumanjayi Walker's family and the broader Yuendamu Walpiri community may be present in the court or listening, and I just wanted to say a couple of words. Firstly, to pass my sincere condolences upon the loss of Kumanjayi, and I feel for his extended family and the Yuendamu community in their anguish and pain at his loss. Obviously, I am Kardia, not Yapa, and I do not have any in-depth knowledge or understanding of Walpiri history, language or customs. I think that I, like many other Australians, Kardia, am poorer for not having this knowledge and understanding. I'll try to answer all the questions that are asked of me in as honest and as sensitive a way as I can, and I apologise in advance for anything that I might say which you may find offensive or disrespectful. While I've been to several locations in the Northern Territory, both for leisure and for work, I also haven't had the opportunity to actually ever visit Yuendamu, so I wanted to make that clear as well. From time to time during my career, I have had the opportunity to spend short periods in the Northern Territory. The most recent was last year when I worked for a short period in Uluru-Kata-Tjuta National Park and also in the Kakadu National Park. And it was an absolute pleasure to be able to do that. The Northern Territory is obviously unique and diverse and rich and in many ways unlike the rest of Australia. I also want to say that my work over the years has involved interactions with many members of the Northern Territory Police. And I have many friends in the Northern Territory Police, and as such I've come to deeply respect the challenging nature of policing in the NT. I do have some awareness of the tyranny of distance and the challenges of remote localities and the vast distances and limited resources and other challenges that are faced by the NT Police. Obviously, the majority of my law enforcement service was with other agencies. I did work in community policing in the Australian Capital Territory, which has a different set of challenges, and also with national law enforcement agencies such as the Australian Federal Police and the Australian Crime Commission. So I haven't served as a police officer in the Northern Territory. I haven't worked in a remote community such as that, other than my service in places like Bougainville and the Solomon Islands. therefore, like everybody, my views are largely through the lens of my own lived experience. The opinions that I express, relating to management and leadership and use of force, are obviously drawn largely from my own experience, and I have had the opportunity to assess the material which was provided to me in the lead up to the trial of Zachary Rolfe. However, unfortunately, I haven't been able to follow in detail the workings of the inquest, and it's probably fair to say that I haven't heard most of the evidence given by the witnesses that you've heard from. That said, some of the things I say are strongly worded, but I do wish this court to know that everything that I say is simply aimed at contributing to institutional reform, and I don't say anything with any malice or ill feeling. Thanks, Your Honour.
Thank you.
Mr McDevitt, I won't go into detail before I go any further. I also wanted to acknowledge, because it might be significant to those listening, that you've made yourself available at a time of quite extreme personal difficulty, and that it's a measure of your commitment to this process that you've done that. So thank you for being here.
Thank you.
Now, I'll come to the nature of your experience, study and qualifications in a moment, but certainly you were called at the trial of Constable Rolfe as an expert in police use of force training and methodology, is that correct?
Yes, that's correct.
And you gave a report for the purposes of those proceedings on the 29th of June 2021?
Yes, I do, and I've got that report with me.
And, Your Honour, for the record, that's at 10-26 of the brief. And you subsequently gave evidence at Constable Rolfe's trial on the 8th of March 2020.
Yeah, that's correct.
And, Your Honour, the transcript of that examination is at 10-27 capital A. Now, because I'm aware that we're pressed for time, I won't ask you too much in detail about the opinions themselves, but I thought that I might summarise them. Your opinion in respect of the events inside House 511, and in particular in respect of the 3 shots fired by Constable Rolfe, was that the firing of those shots in those circumstances was lawful and consistent with relevant Northern Territory Police Force policies?
That's correct. It was consistent with the policies and with the training.
However, you were also of the opinion that when trying to understand what went wrong, if anything, on 9 November 2019, it was necessary to take a broader view and not just focus on the events that occurred inside House 511.
Well, yeah, that's correct. In a nutshell, my personal belief is that those 2 young men, Kumanjayi Walker and Constable Zachary Rolfe, probably never should have met. And I believe that, quite frankly, the reasons that they did was largely due to a tragic failure of leadership.
And some of the issues you identified were issues of planning, for example?
That's correct.
Communication?
Yes.
And when I say communication, I want to be clear, we're not just talking about the communication between the members of the IRT while they were on the ground, but also talking about communication between that unit and the police forward commander, to the extent that there was one, Sergeant Frost, and members of the executive who may or may not have been involved in the deployment of the IRT.
Well, that's correct, and largely my view is there was just a significant lack of executive oversight.
And finally, you identify problems of leadership, as you've just said, and I think that the most significant one was that there was a real lack of clarity about who the leader was during that deployment. Would you agree?
That's exactly right. There was no clarity whatsoever of leadership, of command and control. There was no underlying risk assessment. There was no proper planning process. There was a sort of a plan, and if you want to, I'll talk about that plan, which I believe was fundamentally flawed anyway. But I just think there were just a whole range of factors, largely that really go back to the events of 6th November. And I think if the response to that had have been handled correctly, then that's why I say I don't think those two young men would ever have met.
And so what I might do is call them the systems failures, if that makes sense.
That's correct.
But you also identified in your report and at trial, or made some criticisms of some of Constable Roll's broader conduct leading up to his entry into House 511.
That's correct.
And I won't take you through these exhaustively, but they included, for example, the observation that Constables Rolfe and Ebel allowed themselves to get too close too quickly to Kumanjayi Walker within House 511.
Yeah, but that's correct. I think the problem for them, and I've seen it, on a multitude of occasions, is that they seem to have put the priority of identification of who it was that they were talking to up front, and that led them, I think, to close the gap with Mr. Walker, which I think they shouldn't have done. They could have established his identity from a safer distance, if you like.
And indeed, I think that's exactly what you said at trial, page 1262, that this singular focus on getting in there and establishing identity and closing the gap meant, in your opinion, that there wasn't enough of a focus on their own safety, for example.
Yeah, that's correct. And as I said at the trial, I mean, your safety is largely reliant on your reaction speed, a large factor, a large component, which is distance itself. You need distance to be able to respond in time.
And so I'm confident that you have set out most of these observations in your report and your trial evidence. So I'm not saying they're not important, but given the time, I won't go through each of the observations you made at trial. But in summary, is it fair to say that when trying to understand why deaths like these occur, and when trying to work out what we can do to prevent similar deaths in the future, we need to rigorously examine both the conduct of individual officers and systems that might have failed or failed those officers?
Yeah, well, that's exactly correct. I mean, the ethic of minimum force shouldn't be about sort of management rhetoric. It should be, something about the whole culture of the organisation, part of the DNA of the organisation.
So what I want to quickly do before handing over to some of the other parties is ask you some questions about qualifications and experience. Now, during your opening comments, you said something about the nature of your experience with the AFP and in the Australian Capital Territory. Mr. Edwardson QC in fact took you through your experience at trial, and I think you agreed that you were the longest serving member of the AFP Special Operations team, is that correct?
At the time that I left, that's correct. It was in the order of 12 years.
And the Special Operations team with the AFT is in effect the equivalent of the Northern Territory's TRG.
That's correct.
You were Chief of Firearms at the AFP?
Yes, I was the Chief Firearms Instructor for the AFP and Chief Defensive Skills Instructor for the AFP. So basically what that meant was that I was responsible for training of AFP members through the whole spectrum of use of force, right from everything from teaching recruits how to use handcuffs through to training the special operations team on how to deploy gas or breach a terrorist stronghold, etc.
And you're also a trained police negotiator.
That's correct.
Just wanted to ask you two questions about your experience, one of which I think you've already answered. I think you recognise that although you have some training and experience that is very valuable when trying to understand what went wrong on the 9th of November 2019, you also recognise that you gained that experience in a very different policing context.
That's correct.
For example, dealing with matters like counter-terrorism, large-scale drug importation, things of that kind.
That's correct.
And that you respect that policing in the Northern Territory. I withdraw that. The second matter I wanted to ask you about, and this is another matter that was highlighted by Mr. Edwardson at trial, was a report you authored in 1996.
That's correct. That was I started in about 1994 and I think completed it in 1996, and it was an entire review of everything that the AFP did in relation to use of force. And to be frank, I think we had some fundamental issues to deal with in that at that time the use of force training seemed to be focused on the higher levels of use of force. So, for example, and these aren't the exact figures, but if you had a sort of 5-day use of force program, maybe 3 days might have been spent on the range, which is important in its own right, because if you're going to give an officer a firearm, then they need to be trained to use that correctly to the extent where that they can almost gain what we call an unconscious competence in the use of the firearm, for in a critical situation. But, what you got to remember is that most arrests are made without any use of force. And I always used to tell recruits and everybody else that an officer's verbalisation skills would save them long before any marksmanship ability or physical prowess, and also that aside from entrenched corruption, police use of force or abuse of force is probably the greatest threat to an organisation's image. The potential to degrade the image and the trust held for a policing agency. As I say, other than entrenched corruption, I can't think of any other issue that can, bring grief to a law enforcement agency than an abuse of force. And that was why I conducted the review, because I wanted to shift the emphasis entirely from hard skills to soft skills for confrontation management. And I don't know if you've got the report there or had the time to look at it, but I made, I think, 27 recommendations. A lot of them were about, giving police better and more training in soft skills like, dealing with difficult people, dealing with minority groups, cultural awareness, learning about their own biases, in particular at that point in time, dealing with the mentally ill, because around that time there had been a lot of police shootings, a number around the country, but predominantly in Victoria. And this whole sort of notion or phenomenon of suicide by cop was very prevalent, and there was a lot of work going into that. And I went to Victoria and worked with them on what they called Operation Beacon. And a lot of effort going into, other ways of confrontation management. And, there were a lot at that time. There wasn't things called tasers, but there were things called stun guns, and OC spray was just making its presence, and I recommended that we introduce OC spray into the AFP, and it took me 3 years, but we did introduce it.
So, Mr. McDevitt, I don't mean to cut across you. I just might unpack a couple of parts of that. Before I return to the subject of the report, your understanding it is, and the evidence at trial was, that the new model you proposed was adopted by a number of police forces around the country with some minor amendments?
That's correct. To my knowledge, they all pretty much adopted the model, as actually did the United Nations for their peacekeeping missions.
And in particular, there was evidence at trial that the Northern Territory Police Force's 10 operational safety principles, which begin with the overarching principle that the success of an operation will be judged by the extent to which force is minimised, were very much based on your work.
Yeah, well, each force sort of couched it slightly differently in their own words, but essentially that's true. That was the overriding philosophy.
I just want to circle back to one of the problems, and I should say that your report has been circulated to the parties and is now an exhibit on the Coronial brief. I wanted to circle back and ask you a question about one of the things that you thought hadn't been the focus of sufficient attention in police use of force policy and training, and needed to be the focus of attention in training and policy in the future. And that was the issue of bias and a lack of cultural awareness. You recall that the report deals with that issue?
Yes, that's correct.
And in fact, at page 8 of the report, you said that when teaching officers to use force safely and when assessing their use of force in hindsight, bias and cultural awareness training was vital. Do you recall that?
Yes, that's correct.
And indeed, you said that it was vital that police officers ask, and I'm quoting from you, what bias and cultural baggage are we carrying?
Yeah, I think that was the words I used.
Why are issues of bias or a lack of cultural awareness so important to understanding the use of force by police officers?
Well, there were a whole range of issues in that, but I guess at that time I don't think we were, people would say, I'm not biased against any particular. And back then we used the terminology minority groups, which I don't know if that's appropriate now, but that was what we used. And I mean, it was sort of largely it was about looking at not so much explicit or conscious bias, but subconscious bias, implicit bias that was maybe it was, when we were young children, and by the time we were sort of, certainly less than 10, we'd sort of formed views. And I don't know, when we got on a bus, if there might be a disabled person sitting on a seat, and we would just choose not to sit next to that person, or we would. Yep, sorry.
Oh, no, I cut across you, but I was just going to say, so these biases can be quite subtle or even poorly understood by an individual police officer.
That's correct.
But your opinion, based on your considerable expertise in this area, was that they could still influence police decision-making about use of force in ways that needed to be avoided or confronted.
That's exactly right.
I think as a part of your overhaul of the AFP's firearms training, you made some recommendations about target practice. Can you tell Her Honour what that was?
Sorry, about the targets that we used?
Yes.
Yeah, well, one of the recommendations that I made at that point in time was to move away from targets which were actually black in colour, which I didn't think obviously was appropriate, but there was nothing really sort of sinister. You know, if you look at the history of the sort of the development of the target, it was really when you're on a on an outdoor shooting range, if you shoot at a white target at a distance, and hopefully if you're lucky enough to hit it, there would be a small hole where the light would come through where the projectile had hit, and that's really hard to see on light coloured paper, and so historically that was why black paper was used for targets. So there's nothing sinister in it, but obviously when I was sort of doing this whole review, I just thought that was inappropriate. So I recommended we move away from that, and we did.
Is it your opinion that something as simple as shooting solely at black targets might create or compound some of these subconscious and very subtle biases that then affect police officers' decision making when they use force?
It's a good question. I'm not really sure, and I don't know what evidence there might be to support that. But
perhaps leaving the targets to one side and just taking the other subconscious or subtle racial. Let's deal with racial biases for a moment. The reason that it's so important to understand and confront these is that they can affect, for example, a police officer's perception of risk when using force.
That's correct.
So, for example, it might cause the officer to assess a person of a particular race as being a greater risk to the officer.
Yes.
Conversely, it might cause a police officer to be less concerned by the risk their conduct poses to a person of a particular race than they might otherwise be.
Yes.
And ultimately, that's in large part why your report recommended that to ensure that the use of force by an officer is safe, racial biases need to be identified and confronted by police forces.
That's correct.
And that when looking to past instances of uses of force, and when trying to understand what happened and why, identifying any racial bias might be quite important.
Absolutely.
And when looking to the future, identifying such biases is essential to ensuring that force is avoided when it is avoidable.
Yes.
Okay. Now, obviously that requires a commitment by the executive, the force itself. Would you agree?
Absolutely.
But it also requires a commitment from individual officers.
Yes, that's right. It flows down.
For example, it requires officers to demonstrate some insight into their own biases or racism.
Correct.
Because if they don't, we can't be sure that they're safe when using force.
Yes.
No further questions, Your Honour.
Mr. Mullins.
Thank you, Your Honour. Mr McDevitt, my name is Mullins. I appear on behalf of the Brown family. Can you hear me clearly?
Yes, I can, sir.
I'm going to keep my voice raised, not because I'm yelling at you, but I want you to hear me.
Okay.
All right. In your report of 29 June 2021, which has been identified, you make reference to the incident of 6 November 2019.
Yes, that's correct.
And you've said again this afternoon that that was a particularly important aspect of the interaction between Kumanjayi Walker and the police.
Sorry, the interaction 3 days later?
Correct, 3 days earlier. So the event of 6 November 2019, you say, was particularly important.
Yes, I think it was critically important.
You described that as being highly dynamic,
Yes,
very unpredictable,
yes,
and extremely dangerous.
yes.
And you only needed to watch the body-worn video to determine that that was the case.
Yes, I did, and I read a number of statements that were made by the officers involved in the lead up to the committal, and read their evidence at the committal as well.
And from your expert knowledge, you considered that any person who engaged with Kumanjayi Walker in an attempt to arrest him after that needed to exercise extreme caution.
Yes, I did, and particularly, I mean, at the time, on the 6th of November, when those two officers went to arrest Kumanjayi, the primary purpose of the arrest, as I understand it, was that he was the subject of an apprehension warrant, which they were required to act upon. But once he had instigated that attack upon those two constables, where he threatened them with the axe and then escaped, he had then, by that very action, I believe, made himself a much higher priority in terms of the requirement for him to be arrested and be brought to justice. And so, it's probably open to consider that in his own mind he had now gone way above and beyond what had happened, in terms of being wanted on the warrant, and he had now committed, I think what Sergeant Frost described as a serious and significant assault against the police. So that now became the primary cause for the requirement for him to be apprehended, certainly in my view.
Now, I'm going to do your research a gross injustice by trying to summarise it in 60 seconds. Prior to the time that you did your assess and reassess model, the approach to often the application of force was linear, in the sense that police officers moved from one step to the next until they got to the most lethal form of force. That's right?
Yeah, that's correct. That was the general thinking. I mean, they still had the latitude, if the circumstances dictated, to move directly to a higher level of force. But the general thinking was that they would progress through that linear model, and then, so I shifted it to a situational model.
And the situational model allows it, in fact, to de-escalate and continue to de-escalate if possible where necessary.
Absolutely.
And it's about assessing and reassessing and not necessarily moving forward in the linear model.
No, that's right. And that was why I called the report Assess and Reassess, because that was the critical step in the cognitive processes that go through our minds, all of us, not just police, when we're confronted with a threat. We perceive the threat and we assess the threat as to whether the danger it presents to us, and then we formulate a response, and then we direct the muscle action to implement that response. And so you've got to constantly be assessing the threat, particularly in a dynamic situation.
Now, you say in your report there are multiple failures in the preparation for an execution of this particular event, and Counsel Assisting has taken you to some of those, including the absence of any risk assessment.
Absolutely critical.
The absence of any plan.
That's correct. There was a plan of types, which apparently was debated as to who'd seen it and when. But even if you looked at the plan in its entirety, quite frankly, it wasn't a proper plan anyway, in my view. But yeah.
One witness has expressed their view that if the plan wasn't clear, it was up to the IRT members to go back to the forward commander, Sergeant Frost, to clarify that. What do you say about that?
Well, I mean, as I understand it, Sergeant Frost was appointed, I think, by Superintendent Nobbs to be the forward commander for the operation. So it was, critically important for her to make sure that all the assets under her command who are going to be involved in that operation were very, very clear on the plan, on the roles and responsibilities, on the mission that was to be achieved, and on how it would be achieved.
You also say that the absence of any leadership was a significant failing.
Well, it was just totally lacking. I mean, the members of the IRT themselves didn't know who was in charge, and then when you go higher, it doesn't seem that people knew who actually was in charge at an executive level as well, who was keeping an eye on this. I mean, the classic example is apparently, as I understand it, Superintendent Nobbs didn't even find out there'd been a shooting from his own police on the ground. He apparently found out from some health rep or something. And that just shows what a breakdown in communication you've got.
You lay the blame for this at the feet of senior executive and management.
That's right.
But the IRT were trained. The members of the IRT were all individually trained. Why should they not take responsibility for this?
Well, I think they did have responsibility. Of course, they had responsibility at the tactical and operational levels. Once they were committed to the operation, then the decision making was over to them. But their guidance should be strict and should be within parameters, and it should be absolutely crystal clear to everybody what the command and control arrangements are, exactly what resources were available and were used. And, quite frankly, for something like that, in my view, 4 men and a dog just doesn't cut it. But that's what they had on the ground, and I'm sure they would say they did the best that they could with what they had. But it's up to the executive and senior management to allocate. And if you look at the general order that they've got on use of force, that is one of the responsibilities of the senior executive, to ensure a risk assessment is done and adequate resources are allocated. And when you've got a commander and a superintendent who neither have seemed to have found the time to even look at the body-worn video before they dispatch these people, then with no risk assessment, then how could they possibly have known whether or not those resources would be adequate?
You mentioned in your report and in your evidence that when Constable Rolfe went to house 577, so that was the first house that he went to, that it was appropriate, as I understand it, that he had his hand on his gun as he made his way around the house?
Yes, I believe it was. My understanding is that's the exact house where the incident occurred 3 days prior. Correct me if I'm wrong on that.
And by having his hand on his gun, he was ready to go to the most lethal source of weaponry that he had. That's right?
If necessary.
Yeah. Now, at the Supreme Court trial, you were asked some questions about the evidence of Senior Sergeant Barham. This is at page 1252 to 1253 of the transcript. I'll just read it to you, but you agreed with this proposition, and I just want to make sure that you haven't changed your view. Sergeant Barrett had said this: "It appears to me that Rolfe fired shot one in defence of Ebel. In line with training to have drawn and fired his firearm, Rolfe must have formed the belief that death or serious harm would result to Ebel, and that he had no other option other than to shoot to protect Ebel from being stabbed. And that was you agree with that proposition. Do you still agree with that proposition?
Yes, I did, and if I recall correctly, I was actually led through each of the other options that may have been available, and just went through them and explained why, in my view, they weren't appropriate.
And in fact, you thought all 3 shots were appropriate?
Yes,
And it's the case, isn't it, that you considered that that it was reasonable. Let me go back a step. There are 2 components to this. First is that you accept that Rolf must have formed the particular belief that Ebel's life is in danger. That's right?
yes,
Now, even if you had assessed that it was reasonable to do that in that context, it may still be that Constable Rolf, if he gives evidence to this court and says, well, I didn't hold that belief, you're not saying he held that belief, you're just saying that the evidence that you had seen supports that.
that's correct.
Yes. Now, can I just ask you about the 20 seconds between when Constable Rolf was checking Kumanjayi Walker's identity on his telephone and the first shot? Can I ask you about that?
Yes,
All right. So, in your report, at 7:21:41, Constable Rolf holds up his phone next to the face of Kumanjayi Walker, who was then calling himself Vernon Dixon, to check his identity. That's right?
yes, that's correct.
Now, when he's holding up the phone to check the identity, Constable Rolf is very close to Kumanjayi Walker.
Yes,
And he's showing no concerns whatsoever about his safety, knowing full well that that might be Kumanjayi Walker.
yes, that's correct. And that was one of the, that was one of the areas where I thought there was a tactical error made by the constables, that they had, I don't know if they had sort of accepted the ruse that was being put forward by Mr. Walker, that he was Vernon Dixon or somebody else. And the way it seemed to me, on looking at the video footage, if I recall, was that when he held the phone up, it almost looked as if you see Kumanjayi Walker's eyes also turn to the phone, and it seemed that to me that it could be open to consider that both he and Constable Rolf probably realised that the photo actually identified him not as Vernon Dixon but as Kumanjayi Walker.
So then 9 seconds later, at 7:21:50 seconds, Constable Rolf starts to use what you call soft hands, which is that he puts his hands on Kumanjayi in close range.
That's correct.
He is
I
still...
think it was a hand, wasn't it? On the, sorry, just correct me if I'm wrong. I'm not reading my statement at the moment. I think he put a hand towards the chest of Kumanjayi. Is that right?
Correct. So when he does finally identify that it is Kumanjayi, he shows no signs of any concern, from what you can see on the video footage.
Oh, no, I wouldn't say that. I think he recognised probably about the same time as Kumanjayi. I'm not necessarily saying that is the fact that Kumanjayi also recognised that the photo was him, but it seemed that way to me. And I think very shortly thereafter, Kumanjayi was directed to turn around, I think, to put his hands behind his back, and it was then that he made the choice to launch the lethal attack on Constable Rolf.
Correct. So the stabbing, according to your report, occurred at 7:21:57, and then the first shot occurred at 7:52:01, 4 seconds later. That's right?
Sorry, I can open up my report if you want me to, but I take it what you're saying is right, yeah. Did you say 4.1 seconds?
Yes, correct. So between the time that he put his hand on his chest and the time of the first shot was about 10 seconds.
Yeah, if that's what it shows there in the.
Can I ask this question? In your experience, is it unusual in this type of situation to go from almost no fear or no apparent concern about a suspect to lethal force in 10 seconds?
Yes,
You would have often
I
seen...
think that's entirely possible, and particularly with edged weapons. I mean, the stats show that many victims of edged weapon attacks, that they don't even know that they're under attack until it's too late.
And you would have come across many situations where a police officer confronts a offender with a weapon and there's a standoff.
Yes.
And that ultimately results some seconds later in a shooting.
Yes.
And the police officer right from the outset recognises this is problematic. You understand that?
Yes.
Yeah.
Yes.
In this situation, what we see is 10 seconds of no expression of concern whatsoever, and then within a very short period of time, immediate access to the most lethal option available.
Well, it went from sort of zero to all hell breaking loose, in less than 10 seconds. I mean, suddenly Mr. Walker made the choice to use the weapon that presumably he'd secreted and had ready to launch that attack. And so, thankfully, Constable Rolfe had the wherewithal, I think, to look like he sort of slightly deflected that. He was still stabbed, as we're all aware, but, a couple of inches the other way, that could have, been his carotid artery or whatever. So it was just, extremely dynamic, extremely dangerous. And yes, very, very quick.
Yeah, and is it the case that the circumstances that we see here are equally consistent with an instinctive reaction from Constable Rolfe rather than the assess and reassess application of your program?
No, I think he's in his mind, he's obviously gone through that constant assessment process, and that can happen extremely quickly.
Well,
and I think that's exactly what he's done.
He hasn't given evidence to this inquest, and hopefully he will soon, but you say to use your process of assess and reassess, he would have had to gone through that process in those few seconds.
Yes, so it's a constant assessment and reassessment of the threat, of what you're perceiving through your senses, so what you're seeing, what you're hearing. Did he feel that edged weapon strike him? I'm not sure.
See, the problem is, just one last question. Sorry. The problem is in the first 10 seconds, when he realises that this is this extremely dangerous person, he doesn't respond at all by any apparent concern about being in such close proximity to this extremely dangerous person.
Your Honour, I object before the question's answered. Constable Rolfe's trial evidence is on the brief. It explains what he might have been thinking of doing in that 10 seconds.
Your Honour may not accept the trial evidence.
The fact he hasn't given evidence in this inquest doesn't matter.
Your Honour may not accept the trial evidence, and Your Honour may reject that evidence. I'm putting the proposition to this witness on the basis that, in due course...
What can be seen on the...
Correct.
Which is the basis of his opinion.
Correct, Your Honour. Yeah.
Well, not only that, Mr McDevitt was present during Constable Rolfe's trial evidence. And body-worn video, as we know, has its limitations.
This witness can express an opinion based upon what he's seen, because he's already done that. And I am dividing those two components to what Constable Rolfe actually believed, which is a matter for his evidence, and then what can be discerned from the body-worn video footage, which this witness has been talking about. I've forgotten the question now.
He didn't exhibit on the body-worn video any apparent concern for his safety once he identified who it was that was standing in front of him.
Correct. And maybe the way Your Honour framed it is better than the way I framed it.
I think you're just
No, it's
Polite.
from the body worn video that you saw. That doesn't demonstrate any concerns by Constable Rolfe after he discovered that he was dealing with this extremely dangerous and violent offender.
Yeah, well, I mean, at that point, of course, there was no visible weapon available to Mr. Walker as far as Constable Rolfe was aware. So it seemed to me that as soon as the identification, as soon as he had satisfied himself that this in fact was not Vernon Dixon, he then moved to a position where he wanted to apply handcuffs and take Mr. Walker under arrest.
Yeah. Thank you, Alan. Nothing further.
But before he had the chance to do that, so that was that was within that 10 seconds. But it was then that Mr. Walker made his own choice.
Thank you, Mr. McDevitt.
Yes.
Mr. McDevitt, can you see and hear me?
Yes.
My name's Murphy and I'm one of the lawyers for the North Australia Aboriginal Justice Agency, which is Aboriginal legal aid in the Northern Territory. And the structure of my questioning will be that I'll ask you a few general questions about really the nature of your opinion. Then I'll ask you some questions about your experience, and then I'll ask you some questions about the particular opinions you offered at the trial. So first, and this is sort of an abstract question, but your evidence at trial was that Constable Rolfe's use of a firearm to shoot Kumanjayi Walker on the 9th of November 2019 was necessary, appropriate and proportionate. That's right?
That's correct.
And do you agree that in determining whether something is necessary, appropriate and proportionate, it depends on what you know about the circumstances surrounding the event? Would you agree with that?
Yes, that's right.
Would you also agree that when you're assessing whether a person's conduct is necessary, appropriate and proportionate, it depends on how you define the conduct, as in how narrowly or widely you've set your lens. So I'll give you an example of that and then ask you whether you agree. You've got a police officer, imagine, who goes up to a civilian and pushes a civilian without provocation, just walks up to them on the street and pushes them. The civilian then reacts negatively, gets in an argument, pulls out a knife, and the police officer ends up tasering that person. Presumably in those circumstances, if you just looked at the conduct of the police officer tasering the individual in response to an edged weapon being produced on the police officer, you might say it's reasonable or necessary, appropriate and proportionate. Is that right?
Well, yeah, I mean, you can only judge the incident on the sort of, the start and finish point as you know it. Is that what you're getting at?
Yeah. And doesn't it depend where you set the start and finish point of what you're assessing?
Potentially, yes.
And in terms of the very specific and really the focus of your evidence at trial, I appreciate that you did traverse the events leading up to the shooting, but the focus of your evidence and your opinion was that the 3 shots fired by Constable Rolfe in House 511 were necessary, appropriate and proportionate. Is that right?
That's correct. The majority of my evidence focused on, I think it was a period of 3.1 seconds between shot 1 and shot 3.
You weren't, as I understand it, specifically asked, and nor did you specifically provide an opinion about whether all of the concatenation of events leading up to those 3 shots could have been done in a more appropriate way in order to avoid those 3 shots being fired. Is that a fair summary of what your evidence did focus on and didn't focus on?
Yeah. Well, sorry, I haven't read my evidence recently, but primarily it focused on what occurred in House 511.
I'll just move to the second of the three topics, and that's your experience in, well, really your experience and expertise. And I'll just reel a few off and then ask you if that's all correct. Your expertise and experience includes being a member of what you describe as a specialist assault team for 12 years, being trained as a sniper, being trained in chemical munitions, expertise in how to assault a terrorist stronghold, experience negotiating with warlords in foreign militia, and coordinating the AFP's investigating response to terrorism, people smuggling, money laundering, and the like. Is that they all fair summaries of aspects of your expertise and experience?
That's correct.
And this is not a criticism, I'm just trying to get clarity on this. In answer to a question from the council assisting earlier, I think you said your only experience in community policing in Australia is in the Australian Capital Territory, is that right?
That's correct.
And I think you tried to make this clear at the outset in your statement, and you also said it at trial, that you don't have any experience policing in Aboriginal communities in the Northern Territory, or indeed, for example, Western Australia, do you?
No, I don't.
Is it right then that you don't have any personal experience planning the arrest of an Aboriginal person? Is that right, in a remote community?
That's correct.
And certainly that would mean you don't have any experience in planning the arrest of an Aboriginal person in a remote community who might have an intellectual disability, who might speak a language other than English, that's correct?
That's correct.
You don't have any experience working with Aboriginal elders in remote communities to facilitate arrests, is that right?
It's not in Australia. I did a lot of that type of work in the Solomon Islands with chiefs and elders of various remote villages negotiating arrests of militia group members there, but no, not in Aboriginal communities.
And certainly you wouldn't suggest that your experience negotiating for the surrender of militia groups in a foreign country is readily transposable and applicable to the context of a remote Aboriginal community in the Northern Territory, would you?
I don't think.
You don't have any personal experience utilising an Aboriginal community police officer to facilitate an arrest, that's correct?
No.
And you haven't had the opportunity to work on the ground in remote Aboriginal communities in the Northern Territory and observe remote police officers, including non-Aboriginal police officers, who have skills in communication such that they're able to go a decade working on the ground in these communities, able to go a decade without withdrawing their firearm from its holster. You haven't had the opportunity to observe that kind of work.
No.
I'll just now move to the third and final bit of my questions, which there's a few, but it shouldn't take us more than about 10 minutes. It's about specific aspects of your opinions. And the first is about really the arrest attempt, or what became an arrest attempt on the 9th of November. You said earlier in response to a question, I think from Mr. Mullins, quote, 4 men and a dog doesn't cut it, end quote. Were you trying to say there that really the 4 IRT members and a dog unit, in your opinion, that they weren't adequate resources for this planned arrest?
That's correct.
And it was your view, for example, and you've said it in your first report, which you can refer to if you need to, but consideration should have been given to, for example, enhanced surveillance capacity, such as drone capability?
That's one of the possibilities, but the other that I actually had in mind was exactly what you just referred to, which was use of the Aboriginal community police officers and the people there with local knowledge being utilised as well, and we didn't see that either.
You certainly refer to trained police negotiators. You refer to them in combination with the TRG, but can I suggest to you that at no point in your written reports or trial evidence, do you ever suggest that what should have been used was Aboriginal community police officers? I suggest to you that sitting here now is the first time you've said that that's what you were trying to get at.
Oh, and I'm just considering use of the full resources that were available at the station being available as well. But primarily my focus, yes, was on the TRG, and if the TRG hadn't been involved, as they should have, given their general order says that any warrant, whether an arrest or search warrant, where resistance is anticipated, then use of the TRG should have been considered. I think if the TRG had responded to that, it wouldn't have been 4 people and a dog.
It could potentially have been more people and more firepower, is that right?
Potentially, it could have been more firepower. Could have been more less lethal options. Could have been negotiators. Could have been the use of drone technology. Could have been a whole different strategy with just waiting for a few days, observations, that sort of thing.
But just to be clear, you thought four IRT members and a dog were inadequate, and the TRG should have been sent in to arrest this 19-year-old Aboriginal man in his community at the time of the funeral. That's your opinion?
I believe serious consideration should have been given to the use of the TRG, and at the very least, I believe if that were considered, you would have seen a risk assessment prepared, and you would have seen a lot more consideration go into the planning of the operation, which would have been a much safer result for everybody involved.
You've said that you think your opinion is that serious consideration should have been given to TRG. Can I just suggest to you that in your written report you've gone further and said, quote, should have been activated, end quote. So do you agree that your written opinion was not just that serious consideration should have been given to TRG, but they should have been activated for this arrest?
I think they should have been, because I think if serious consideration were given to use of the TRG, and if you had a look at the general order and you saw the requirements, I think there was about 5 or 6 potential requirements whereby a TRG would be involved. And I think in this instance, you would have ticked off 3 or 4 at least of those requirements. And I think I've gone to that in my statement. I can go to it now if you want me to. I've got him.
Oh, no, that's sufficient for my purposes. You disagree then with evidence that the coroner heard this morning from an emeritus professor who's an expert in the militarisation of police. You disagree with the opinion she gave, which is that groups like the TRG should only be used for sieges or counter-terrorism. You disagree with that?
Oh, I'm sorry, I didn't hear her evidence, but with my history with the special operations team is that they can be used for domestic purposes where it meets certain criteria, such as you saw listed in the general order for the TRG. So where there was a high risk domestic incident, which was not necessarily a terrorist incident, and don't forget, a lot of terrorist incidents you don't know that it's a terrorist incident until later on, particularly if it's a lone wolf type incident. That yes, you could and would use all the assets available to the police service, which would have included specialist police. I don't see why you wouldn't do that.
And is one of the reasons you think you need these specialist units for something like this is that you don't think that general duties police would have had adequate training in these sort of negotiating or safe cordon and containment style arrest? Is that why you need to get the specialist unit in?
Yes, potentially, but you need to realise that the specialist unit isn't just about kicking in doors and rappelling out of helicopters. I mean, the specialist units generally come with the police negotiators as part and package of it, and come with all of the other skills and less than lethal options that just aren't available to general duties police. So because a specialist unit comes in, that doesn't necessarily mean that you're talking about an escalation. You may well be talking about a de-escalation, and chances are you'll probably end up with less danger to the community and to everybody else, because you have brought in the higher level of skills, the people who are trained and practiced at dealing with these sort of events and with offenders who are high risk. So they tend to, do things in a more measured way, and certainly a more planned way, underpinned by risk assessment.
Okay,
So
so
I
that
think protection of the community is often enhanced by using specialist police, I guess is what I'm getting at.
that's comparing the TRG to, for example, the 4 IRT, and you're saying that in fact that could have been a de-escalation, but I don't think you'd suggest, would you, that bringing the TRG in would have been a de-escalation or something less than other options that were available, such as using an Aboriginal community police officer to negotiate an arrest?
Well, I think if the TRG came in, if the TRG came in, they I can't speak for them, I guess, because I don't really know exactly how they work up there or exactly what they have at their disposal. But my sense is that if they were aware that potentially the greatest source of intelligence, for example, which would have been one of their key aims, the key thing they would have done would have been to try to gather as much intelligence as possible. And it would seem to me that most of that would probably reside with the local police officers who had potentially dealt with Kumanjayi in this case previously.
And the reason that this kind of specialist response was necessary in your view is because of, in particular, the axe incident from 3 days earlier, is that right?
Can I just have a look at my notes, Your Honour?
Sure.
You might be assisted by page 19 of your of your statement, and towards the bottom of the page where you've said there was a lack of real sense of urgency.
Yeah. So on page 17 of my statement, where I talk about the TRG, it says there's criteria listed to assist to determine whether a situation is high risk, which includes, and you can see there, the seriousness of the offence committed, the expressed intention of the suspect to use lethal force, and in those, I point out there that criteria 21.1, the BWV evidence provided graphic evidence of a serious offence had been committed by Mr. Walker. It was also a clear demonstration of his propensity for violence, as per 21.4.2, and further, he had a criminal history which included convictions for violence-related offences, and I listed that there, including assault police. And in my opinion, I've said this could be considered a history of violence as per criteria 21. I've put 4.2 there, but it's 4.1. So you can see there's at least 3 of those reasonable grounds which should be considered as to whether or not the TRG would be involved. And if it would be fair for the TRG, if they were notified about this, to probably look to that to make a decision as to whether or not they thought it was something that they should be involved in.
In terms of the level of threat or dangerousness that Kumanjayi Walker posed, this inquest has heard evidence from one of the 2 police officers at the axe incident. Relevantly heard evidence from one of the 2 police officers who said that, in his view, and I'm paraphrasing, but that Kumanjayi Walker's presentation of the acts on that occasion had a cultural dimension to it, in the sense that he interpreted, at least the police officer, that it might be more of a sort of show of force that in the police officer's view might have reflected an aspect of Walpurgis culture, rather than indicative necessarily of preparedness to use that weapon on the police officers that were present. I appreciate you weren't here to hear that evidence, but assuming that I've accurately summarised it, would it affect your opinion of the dangerousness or the level of dangerousness that Kumanjayi Walker posed, if it was in fact correct that part of that axe incident was just a show of force?
Well, I'm sort of I'm aware of that sort of narrative that you're presenting, and I'm not aware of Walpurgis culture, so I'm at a loss as to the extent to which that we could be sure that that was the case, and it worries me that maybe we couldn't be sure of that. And I do remember reading that when that incident occurred, I think there were several people in the house, and I think one of them, it might have been Kumanjayi's grandmother, had been yelling at him to drop it or don't do it or leave it, it's going to get you in trouble or whatever. So, another theory might be that he may have actually been persuaded by that yelling of others to say, no, don't do this, you're going to get into trouble. Or maybe he fully did intend to use the axe to, not necessarily to strike them, but to assist in getting out of that building, and by running at them with it, with an intention to either they're scared enough or move or whatever away from the doorway, or he hits them if he needs be, if he was determined to get out of that door. So I understand what you're saying in relation to the possibility that it was I don't know, like a show of force, which was a Walpurgis thing, but it would be quite frankly, you would have to be really, really solid as to that's exactly what this is about. If you were to let somebody run at you with an edged weapon like that in close proximity, I mean, wow, that would be a big call.
Okay. I've probably got about 5 minutes left. If you're content to sit on.
Sure.
The last two things I'd like to ask you about is the entry into house 577, that's the first house, and then I'll ask you about the shots in the second house. So it was your view and your evidence that Constable Rolfe's decision to enter house 577 was sound, that's correct?
Yes, that's correct.
And that was even though police had been told by a child that Kumanjayi Walker was not in the house, you still considered it sound for them to enter that house?
Well, you've got to be careful because, I mean, that evidence is from a child and it's uncorroborated and it's single source. I personally wouldn't have moved beyond that house until I checked it, given that was the house that Kumanjayi Walker was in 3 days before. I would have checked that house before I moved on. That's my personal view.
And you said that on checking the house it was appropriate and tactically wise for Constable Rolfe to have partially disengaged his holster, is that correct?
I would have, yes.
And in fact, your only criticism of Constable Rolfe in entering that house is that he, quote, should have had the firearm out of the holster ready to deploy, end quote. That's your opinion?
Yes.
And that's even though...
If anything, if I had any criticism, it would have been that in terms of being prepared, in terms of knowing what had happened in House 577 and the likelihood that if Kumanjayi were in there and again decided to take up arms, then just because you unholster a firearm does not mean you're going to use it.
But you've got to be ready to use it.
It is a show of force, absolutely, and it's a very strong deterrent. It's a much stronger deterrent when it's out than when it's in the holster.
And you've got to be ready to use it if you withdraw it from the holster, that's correct?
You would have to be prepared to use it, doesn't mean you have to use it.
No, I understand that distinction. So your evidence is that it was appropriate to enter the house notwithstanding a child had said Kumanjayi Walker wasn't in there, and it was appropriate to not just have the holster partially disengaged, but to have the gun out and ready to deploy. That's right?
You said notwithstanding Kumanjayi Walker wasn't there, that wasn't known to Constable Rolfe at that point. All that he had was a child saying that Kumanjayi wasn't there. Is that right?
Yes, that's right. And all of that was appropriate, that is, entering the house with a firearm drawn, notwithstanding that there was a 10 or 12-year-old child present in that house. That's your opinion?
Yes.
And in fact, at trial you said, quote, I've gone into dozens of houses with far more firepower than what Mr. Rolfe had, which have had children inside them. Do you remember giving that evidence at trial?
Yeah, well, that's correct. I mean, I think the statistics are something like there's 400 houses for every 1,000 Australians across the country. So chances are, if you're going to go into a house, you're going to find children there, more than likely.
And that didn't change your opinion as to the appropriateness of having the gun drawn and ready to fire?
No, but yeah, you trust in the training of police officers in relation to how they move about with a firearm and whether or not that firearm is utilised. But it's unfortunate and it's distressing, but it's a reality that on many occasions police are required in the execution of warrants and so on to actually enter houses with weapons drawn.
Okay, you said trust in the training of the police officers. Does your assessment of the appropriateness of Constable Rolfe going in there, as you say, should with a gun drawn, does that take into account how that might affect the community trust of police in that community?
I think it's fair to say that that sort of activity you don't take it lightly. I mean, it obviously would have been distressing for everybody involved, but I don't think it means that it's not necessary or justified in certain instances.
And when you say you take into account the effect on the community, certainly you'd agree that one big factor would have to be how that 10-year-old kid's ever going to have a positive relationship with police if they've witnessed a police officer roaming through their house with a gun drawn. You'd agree that it's got to be a relevant consideration.
Well, it could be. I mean, I'm not sure exactly what happened as to, exactly where the child had been in the house and to what extent, he saw, where the weapon was actually being pointed at any point in time. Or, I mean, I don't know exact movements within each room of the house. For example, it may have been as simple as Constable Rolfe having the weapon down and glancing in and seeing a child and then moving on. I don't know. I can't recall his exact movements in the house. I don't think. I'm not sure, but I don't think it's alleged that he went in and failed up a child by pointing a firearm at the child or anything like that.
Okay. My last questions are just about the shots that Constable Rolfe fired in the next house he went to, 511. You say that he acted appropriately in drawing his firearm and firing those shots, that's correct?
Yes.
And part of why you say that, and please refer to page 55 of your first report if you need to, is that Kumanjayi Walker had decided to, quote, initiate a lethal attack upon the two police officers, end quote. That's part of the reason that it was, indeed, the reason it was appropriate for Constable Rolfe to draw his gun and fire those 3 shots.
That's correct. He there wasn't just the threat of an edged weapon. It had actually been used upon him.
But can I just say, you actually say, you go a little bit further, not just the presence of an edged weapon, that you say at page 55 of your report that it was Kumanjayi Walker's decision to initiate a lethal attack. Your evidence and your opinion was that Kumanjayi Walker's intent was lethal. That's right.
Yes.
That he
Could certainly, you could certainly consider that. I mean, why else would you launch an attack like that towards the neck region of a police officer?
Well, without necessarily accepting it to the neck region, when you say you could consider that, to you the intent was clear, and in fact you said in your statement, Mr. Walker's intent was clear and was voiced by him even after he'd been shot 3 times with the explanation, I'm going to kill you, and then there's inaudible, possibly mob. That confirmed to you Kumanjayi Walker's intention to kill those police officers, is that right?
That was part of it, yes.
Are you aware that in Aboriginal English the word kill means something different to in regular English, and in fact it can mean just simply hit or injure rather than end a person's life? Were you aware of that? Look, that's quite possible, and it's common in Solomon Islands pidgin as well for somebody to say kill when they mean assault. It doesn't appear that you factored that into your opinion there. Would you agree with that?
Well, it seemed to me that those words coupled with the actual launching of the attack seemed to me to make it pretty clear that in that instance the word kill meant kill.
Those are my questions, Your Honour. I apologise that I went so much over time.
No, I don't think you did go over time. I don't know what limit had been set for you. But can I just clarify something, Mr. McDevitt? You've talked about the entry into House 577 and your view that, possibly it might even have been justified to have a weapon drawn. I'm assuming that from your point of view, going into 577, possibly justifying a weapon being drawn, was on the basis that the police were entering that house in order to effect an arrest if he was present.
That's correct, Your Honour.
And the purpose of entry was in pursuit of an arrest.
That's correct.
We might just break for the afternoon adjournment.
All set for what's on the agenda.
Mr. McDevitt, will be 15 minutes. Welcome to turn off your camera and microphone, and we'll see you then.
Okay.